All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court, sitting en banc, is now in session. Please be seated.
Good morning. Welcome to oral argument. And before I have Jorge Navarrete, our clerk, call the calendar, we'd like to welcome this morning 14 law students from the John F. Kennedy College of Law. Where are you? Front and center. Very good. Thank you for coming. And you're here, I know, with your adjunct professor, Natalie D. Cortasso, and Audrey Smith, your Director of Legal Research. Where are you? Thank you. Thank you for coming and bringing the students. We appreciate it. Clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Thursday, March 8, 2018 at 9 a.m. Case number S239713, the People, Plaintiff and Respondent versus Jesus Manuel Rodriguez et al., defendants and appellants. For appellant Jesus Manuel Rodriguez, Ms. Cara DeVito. For appellant Edgar Octavio Barajas, Ms. Eslyn Klein. And for respondent, Mr. Darren K. Indermill. Case number S113421, the People, Plaintiff and Respondent versus Warren Justin Harding, defendant appellant. For appellant, Ms. Susan Shaler. And for respondent, Mr. Michael J. Wise.
Ready.
Thank you. In the first matter, the People versus Jesus Manuel Rodriguez, we welcome the Honorable Coleman A. Blease, Associate Justice, Court of Appeal, 3rd Appellate District. And you may proceed when you're ready.
Thank you, Your Honor. May it please the Court, Cara DeVito for Jesus Rodriguez. This morning I'll be arguing the second issue granted review, which is the question of whether a defendant moots his constitutional challenge if he is not granted a Franklin remand. In Graham, the United States Supreme Court said that a juvenile offender, and in California we're going to use the term youthful offender, has to have a meaningful or realistic opportunity to obtain release, and Franklin, of course, adopted that language. Graham also said the remote possibility of release does not satisfy the Eighth Amendment. There has to be something more. Absent a baseline, however, we'll be treating youthful offenders in California exactly the same way as we do adult offenders. And by adult offenders, I mean those who committed their crime when they were 26 years of age or older, now that the legislature has defined youth offender as someone who commits his crime at age 25 or younger. Because absent a baseline hearing, defendants such as Mr. Rodriguez and Mr. Barajas, who committed first-degree murder and are sentenced to a term of 25 to life, will move in lockstep with an adult offender of 26 who committed first-degree murder and is serving 25 to life. They'll both be eligible for parole hearings in their 25th year of incarceration. They will both be appointed counsel who can gather information and present it to the parole board. But other than that, there won't be any distinction between them. The parole board, according to California Code of Regulations, Title 15, Section 2281B, will look at both the youthful offender and the adult offender's social history, past and present mental state, past and present attitude toward the crime, and any other information bearing on suitability for release. The parole board is supposed to consider Miller factors, but they may not be available to the parole board at the time of the parole hearing 25 years in the future. If that happens, then you're treating children, youthful offenders, exactly like adults, and Miller says—
Counsel, could I just ask, at this point, the Attorney General has conceded that remand is appropriate?
Yes, for my client and for Mr. Barajas, but to assist the court, I assumed that I would be arguing on behalf of all youthful offenders in California, and not just for those two defendants.
I just wanted to clarify that in light of the concession, the issue of mootness has sort of been resolved, hasn't it? I mean, it's squarely under Franklin at this point.
As to my client and Mr. Barajas, if Mr. Barajas' convictions aren't reversed, then yes,
okay,
it does moot it as to those two.
Thank you.
But for any other youthful offender, we're not treating them as children, and Miller requires that we do. Miller says children are constitutionally different from adults for purposes of sentencing, and Miller says we cannot proceed as though they were not children. In fact, Penal Code 3051F1 and Penal Code 4801C require the Board of Prison Terms to compare children to adult offenders. And we can't do that if we're treating them the same. There are other considerations. An adult who knows his parole date is 25 years in the future knows it's up to him or her to conform his behavior while in prison to maximize his chances of getting parole. But if we accept the fact that children are different and cannot appreciate the risks and consequences of their behavior, then someone such as Mr. Rodriguez, who was 15 years old when he was incarcerated, presumably cannot conform his behavior to try to maximize his chance of release until he ages a little bit. The legislature says until he ages beyond the age of 25. During that 10-year period, he may commit infractions in prison. He may do things that would otherwise render him ineligible for parole at the first possible opportunity. But if he has counsel appointed to go back to the trial court and establish a baseline for him, the parole board has something to look at that they can use to excuse any infractions during that period when he's still a youthful offender, yet living in a prison. There's even a consideration that on remand, both parties are allowed to put information on the record, which means presumably county district attorneys are going to put negative information on the record about a youthful offender. But even that can inure to their benefit, because if a youthful offender can overcome bad things in his background, considering he started so far behind the start line in the beginning, he's overcome that and rehabilitated himself, that could be even more impressive when the Board of Parole Terms looks at his record. There's a question of whether presenting the board with information at the first time parole is eligible will satisfy, and I don't believe it can. As the opening brief on the merits pointed out, traditionally a trial court is where you develop a factual record. And in Franklin, this court remanded the case to the trial court not to hold a hearing, but to oversee the process and say, was there a sufficient opportunity? It's for a trial judge in the first place to say, are we comporting with this in a constitutional way?
So, Ms. DeVito, can I ask you, what is it exactly you want this court to do then?
Establish a bright line rule that for any youthful offender who did not have the opportunity to put on the record Miller factors, there will be a remand to the trial court so the trial court can determine, well, the trial court will make the determination just as it did in Franklin whether or not there was a sufficient opportunity to make a record. But every youthful offender needs a remand at this point.
What, in your case, what are the additional things that Mr. Rodriguez would have wanted to put on the record?
Recall, Mr. Rodriguez has nothing but a fitness report from his juvenile court appearance. The probation report was meaningless in this case. One of his teachers in school had some very positive things to say about him, but unfortunately, we only know that from a settled statement. The transcript is missing. Mr. Rodriguez appears to have had a fairly sad, if not horrific, childhood. He was neglected. One of his parents lived in a different country. His mother apparently didn't care about him. His brother paid him attention by beating him up, and once beat him so badly the brother was arrested. As the opening brief on the merits points out, it establishes a reason why Mr. Rodriguez was so attracted to members of a gang in the first place. The gang gave him acceptance, love, respect, and he was only 15. He was manipulated, possibly, into committing this crime by the 17-year-old co-defendant who entered into a plea and served a minimal sentence. Mr. Rodriguez admitted wrongdoing at a very, very early stage. He willingly admitted every element of both the crime and the firearm enhancement, and in exchange for that, he received nothing except the maximum mandatory sentence that could be imposed upon him. That's another factor to take into consideration. This was a child who...
I want to make sure I understand that argument. There was not a plea agreement in this case, was there?
No, the co-defendant who testified at trial?
Yes.
The accomplice co-defendant who testified at trial.
I'm speaking to your next point, which was that Mr. Rodriguez accepted responsibility and got nothing for it.
Yes.
There was no plea agreement with regard to Mr. Rodriguez.
No, he went to trial.
Thank you.
I'm sorry if that wasn't clear. In regard to the trial judge being the best person to gather the information about a youthful offender, we have a problem if we delay until the time of the first parole hearing, having a court-appointed attorney at that time try to amass information. Mr. Rodriguez and Mr. Barajas are in the most severe situation you can have because they have to wait 25 years before they're going to be eligible for their first parole. We know that memories fade. We know that documents and other evidence can get lost. So by analogy to cases where there's pre-accusation or pre-indictment delay, the United States Supreme Court has said there is a due process problem in those cases because of memories fading, because of a defendant's inability to present a case, and there may be a denial of a fair trial. Those pre-indictment, pre-accusation cases I'm talking about, United States versus Marion and United States versus Lovasco, have been followed by this court, at least in theory, in People v. Archard and People v. Nelson. In this case, both Mr. Rodriguez and Mr. Barajas have already served more than half of their 25 years, just because of the odd procedural way this case has gone. And with every passing day, there's more and more of a danger that we may not be able to put together a full record, which brings us to the second half of that question the court presented, which was not only is the defendant denied his constitutional rights, but can the Board of Prison Terms properly discharge its statutory obligation absent a baseline hearing? If we wait that far into the future until there simply is no information, everyone's been diligent. Perhaps the attorney appointed to represent Mr. Rodriguez at his parole hearing will have done everything he can, but some of Mr. Rodriguez's family live in Mexico. The mother has changed addresses several times, even while I've been representing my client. And it may be that the attorneys will say to the Board of Prison Terms, we just don't have Miller factors to put in front of you. I don't think a board can discharge its obligation by saying, we'll consider Miller factors, there are none on the record, let's just move on to what we would look at ordinarily for an ordinary parole hearing. And Caballero and Franklin both say an accurate record is best made at the time of the offense, or it's a task most easily done at or near the time of the offense. We have to remember that that's a baseline. Graham, at page 70, warns us that the remote possibility of release does not satisfy the Eighth Amendment. So if we are not maximizing a youthful offender's chance to get parole at the first possible opportunity, and a way to maximize it is to establish the need for a baseline hearing, then we are not obviating the Eighth Amendment constitutional violation, which is what this court is most concerned about. Probation reports and juvenile offender reports, fitness reports, none of them can satisfy the Miller factors. If the court looks at what a probation officer is required to put in a pre-sentence report, which is Rule of Court 4.411.5, it's a very, very long rule, but has just one short paragraph requiring that the report contain a defendant's social history. The rest of it concerns itself with the case, victim impact, the defendant's record of prior criminality, and his ability to make restitution, none of which have anything to do with Miller factors. If you look at the general objectives in sentencing, which is Rule 4.410A, seven of the eight subsections talk about protecting society, punishing the defendant, deterring the defendant from committing new crimes by isolating him, again, securing restitution for the victim, and achieving uniformity in sentencing and increasing public safety. Only subsection A3 encourages the defendant to lead a law-abiding life in the future without any consideration of how he can do so or what led him to commit crimes in the first place. And what led him to commit crimes in the first place is what Miller is concerned with. Finally, I want to propose to the court it's not overly onerous to impose a new procedure on the trial courts with what I'm requesting, which is baseline hearings for youthful offenders who have not had the opportunity. First, because ever since Franklin was decided, at a minimum, I think we can presume that trial courts and defense attorneys and prosecuting attorneys are putting Miller factors on the record. Second, we're talking about a limited segment of the prison population, which is youthful offenders, and then only for a very limited period of time. Again, because going forward into the future, I think these things are going to be discussed at sentencing hearings. Now, in last month's opinion, in Re Superior Court, Lara, this court held that Proposition 55 applies retroactively to all juvenile offenders against whom the district attorney's direct filed in adult court. They're all going to be remanded for fitness hearings. And this court said the potential complexity in providing juveniles charged in adult court with transfer hearings is no reason to deny the hearing. The same holds true for remands for baseline Franklin-style hearings to put Miller factors on the record. In fact, because we're talking about a limited segment of society, all the youthful offenders who were anywhere between 14 and 18 when they committed their crimes and who were direct filed into adult court, who are going back for these Proposition 57 remands, are already going to have Miller factors on the record because the juvenile court is going to be looking at those things. So it may not be as onerous as we might otherwise worry.
So, Ms. DeVito, I want to tell you that based on how you and Ms. Klein have divided your 30 minutes, you'll have 1 minute of rebuttal at this point.
All right. Thank you, Your Honor. I will save my 1 minute of rebuttal.
Good morning. May it please the court. I am Lynn Klein and I represent Edgar Barajas. With respect to Mr. Barajas, this case also presents a question of whether there was sufficient evidence to corroborate an accomplice's testimony as required by Penal Code Section 1111. We accept the respondent's concession that there was not sufficient corroborating evidence. However, there are a few points where respondent and Mr. Barajas disagree. One area of disagreement concerns the due process requirement of personal guilt. Under state law, Penal Code Section 1111 prohibits a criminal conviction unless the testimony of the accomplice is corroborated by independent evidence that tends to show that that must tend to connect the defendant with the commission of the offense without the aid or assistance from the testimony of an accomplice. In this case, there was no independent corroborating evidence concerning Mr. Barajas personally, but there was independent corroborating evidence that Mr. Barajas was a member of the Sereno Criminal Street Gang and that members of the Sereno Criminal Street Gang participated in the drive-by shooting and murder. Under Penal Code Section 1111, it's necessary that the corroborating evidence tend to connect the defendant personally with the commission of the offense. State law decisions, state court decisions have held that it's not sufficient merely to connect the defendant with the perpetrator of the offense, and it's not sufficient to merely show that the defendant is a member of a group of potential perpetrators. In this case, that was all that was shown here, that Mr. Barajas is a Sereno, that the offense was committed by members of the Sereno Gang. Therefore, the only way to connect Mr. Barajas to the offense is to connect him through his membership in the Sereno Criminal Street Gang. In 2004, at the time that the offense took place, there were between 600 and 1,000 Sereno members in the Modesto area. Therefore, this evidence casts suspicion on a large group of potential perpetrators. The area where Mr. Barajas disagrees with respondent concerns the due process requirement that criminal liability be based on personal guilt. If Section 1111 states that an accomplice's testimony is insufficient to support a criminal conviction, it necessarily follows that the testimony of the accomplice was not sufficient to establish the defendant's personal guilt. Therefore, for due process purposes, it's necessary to have some evidence connecting the defendant personally to the commission of the offense. It would not be sufficient to show simply that he is a member of a possible group of perpetrators, one possible person among a large group. The other area where we have some disagreement concerns motive, or we may have some disagreement. Mr. Barajas agrees that case law discussing Section 1111 often discusses and addresses a defendant's motive to commit the offense. However, there are two things that are key with regard to motive. One is that the case law that discusses motive always involves an act of the defendant that connects the defendant to the particular offense, or else some piece of physical evidence that connects the defendant to the particular offense. There is nothing stating that motive alone is sufficient. There was evidence in this case of motive, sort of a grand, common motive among all Serenos in connection with a rivalry warfare going on between the Norteños and the Serenos. However, there was no evidence that Mr. Barajas personally had a motive to participate in the drive-by shooting and murder. The evidence concerns Serenos in general. Again, it casts suspicion on a large group of people. Also, motive, as mentioned previously, has not been recognized as something that alone may tend to connect a defendant to the commission of an offense. Often, it exists completely separate and apart from an offense. And the only way that it appears that it can be connected is through the requirement that independent corroborating evidence does not need to establish every element of an offense, but it must implicate the defendant and relate to a fact or an act that's an element of the offense. So in the case of an offense that includes motive as an element, it is possible that motive alone may be sufficient. However, none of the offenses involved here include motive as an element. Mr. Barajas, as mentioned previously, did not have a personal motive. There was no evidence that he had any problem or any conflicts with the people in the Oregon Park area where the offense occurred. The gang expert did say that a person who is a gang member who is victimized or disrespected by a rival from a rival gang member would be expected to get some revenge in order to maintain his or her status in the criminal street gang. However, there's nothing in the record to even infer that Mr. Barajas had a personal motive based on being disrespected or attacked by a Norteño member. There's some evidence of school fights. There's a mention that the school fights had gang overtones, but there is nothing indicating that the school fights were even involving Norteño Sereno violence. The fights may have been an internal Sereno fight. Not all gang fights involve fights with rival gangs. An example is People versus Pedroza, a case discussed in respondent's brief where a gang member was convicted of killing a fellow gang member due to infighting going on within the gang. Not only is there no evidence that the school fights involve Norteño Sereno violence, there's also nothing in...
Can I just ask you a broader question?
Yes.
If we reverse for failure to corroborate, is a retrial possible on this case?
I don't believe so, Your Honor. Section 1111 sets a strict standard for sufficiency of the evidence in a reversal.
In light of the Attorney General's concession, which you accept, wouldn't the move be here for us to remand to the trial court to enter a judgment of acquittal?
Remand to the charge? I'm sorry, I didn't hear you.
I'm sorry, remand with directions that there be entry of a judgment of acquittal?
That would be an appropriate remedy, Your Honor.
Okay.
There was not a request, a motion made in this case at the trial court for a judgment and to be made in acquittal. However, that would be an appropriate remedy.
Is there any other option here, given the concession by the Attorney General and the principles of double jeopardy?
I don't see an option as far as a retrial. A retrial would be barred by double jeopardy.
In which case,
In which
client
case-
wins, right?
Yes, correct. Thank you.
Thank you, Ms. Klein.
Do you want to speak to that last point?
Yes, Your Honor. May it please the Court, Deputy Attorney General Darren Indermill for the people. In light of respondents' concessions, I will attempt to be brief, and I will address Your Honor's question first. Retrial is not possible in this case under Pedroza, Belton, and Falconer, and it appears that a remand with directions to enter a judgment of acquittal, it seems, would be appropriate in light of our concession.
Thank you.
As to the motive and personal guilt points, I've discussed those in the answer brief, and I believe it's been fully set forth, our position in the brief, and I don't believe that this court needs to decide those questions in light of the concession. So unless there are any questions on those, I will make a few brief comments regarding the mootness issue. Counsel referred to the language in Graham, which is where Section 3051 takes the phrase meaningful opportunity to obtain release. And she referred to the language remote possibility for release. And we must consider that in Graham, meaningful opportunity to obtain release stood in stark contrast to a sentencing scheme that did not involve any possibility of parole whatsoever. It was life without the possibility of parole. And the only potential for release in that system was executive clemency. And the court in Graham found that executive clemency was a remote possibility. But here we have parole eligibility that has been granted by the legislature at no later than 25 years. And the parole eligibility itself is what moots the constitutional question. There is no doubt that the juvenile offender in this case and all juvenile offenders eligible under Penal Code Section 3051 will receive a meaningful opportunity to obtain release. Another problem with a constitutional rule that every juvenile offender should be allowed an opportunity for a baseline hearing is that baseline hearings cannot be effectively provided for every juvenile offender. For the juvenile offenders who were already eligible for a youth offender parole hearing at the time Penal Code Section 3051 was passed, a remand to establish a baseline would be redundant or unnecessary. And because the same evidence that would be presented at such a hearing would then be presented right away at the youth offender parole hearing. If we held that a baseline hearing was required by the Constitution, then all of those juvenile offenders who have already had their youth offender parole hearing would be required to be resentenced because under appellant's view, those parole hearings were not a meaningful opportunity to obtain release because they didn't have a baseline. And that is just not called for under the Constitution. Penal Code Section 3051 and its requirement, as this court found in Franklin, that a baseline hearing, or at least an opportunity for one, be had, is a statutory right.
Can I ask you, though, in light of your argument, what it would mean then under Penal Code Section 4801C, which implements the 3051, when the parole board is directed to, quote, give great weight to the diminished culpability of juveniles as compared to adults, and the hallmark features of youth, and any subsequent growth and increased maturity of the prisoner in making its decision. I mean, that seems to suggest that there be some baseline of comparison with the inmate from when they committed the crime to the consideration by the board 25 years later. I mean, it just sounds like it does involve something more than the normal and typical parole board decision assessing risk of dangerousness.
Yes, and we're not disputing this court's holding in Franklin to that effect, but just because a baseline hearing is not held does not mean that the Board of Parole Hearing is precluded from giving great weight to these factors. It just means that the Board of Parole Hearing would be considering those factors based on different evidence or based on more of a general consideration than specific evidence provided as to that particular offender presented earlier in time. But the meaningful opportunity...
They don't necessarily need a baseline because they can pretty much, I don't know, look back, generalize the hallmarks of youth, and then therefore use that for comparing whether or not that inmate is now otherwise safe to release. So they don't need that information, which sort of seems at odds with the fact that we would provide one under Franklin in the first place.
Well, that information is certainly relevant and certainly beneficial to the Board of Parole Hearings. Our only argument is that it's not constitutionally required. It's required under the statute. The relevant question at the parole hearing is not necessarily how far have you come. The question is, are you sufficiently mature and reformed and presently fit to rejoin society? So it's not necessarily a backwards-looking analysis. It is a, where are you now? What kind of rehabilitation have you reached? And are you fit to rejoin society?
Well, your argument that in some cases it may just be too late in the day to preserve some of that baseline information, so there will be some cases in which the overall goal that the Franklin decision was designed to achieve just isn't achievable?
Correct.
What do you think that line is? I mean, that's a hard thing to say. A youth offender who's eligible for parole in the 25th year, let's say on a very serious crime, maybe that person has now served 10 years, 15 years. Is that within your range of this is no longer practical or feasible?
I don't think that we have the record in this case to evaluate where that line might be. It's certainly a baseline hearing for someone who is eligible for a parole hearing, as I discussed, would not be necessary. It's certainly too late for a baseline hearing to provide any benefit for that.
The 2 points are convergent at that point, but I'm thinking about the middle cases, and I'm wondering if you have any objection to Franklin remand in those situations.
The facts here simply do not call for a decision as to where that line is.
But where would you draw the line? I mean, I understand your point about the facts in this case, but help us understand the core of your argument, which is not constitutionally necessary, not necessary for some, but yes for others. So for whom are these necessary?
Without facts regarding how the Board of Parole Hearings actually conducts parole hearings and how that process plays out, we're not in a position to be able to evaluate how effective a baseline hearing will be 2 years in the past versus 10 years in the past versus 20 years in the past. It's something that simply can't be evaluated in this case based on the information that we have in the record.
Is part of your concern that you don't want a rule that says that such a hearing is constitutionally compelled, because down that road lies the problem that in the absence of such a hearing, for whatever reason, or in the absence of somebody who may not currently be available to testify at such a hearing because it's 15 years after the crime, that you're concerned that everybody will throw up their hands and just say, well, I guess we have to let him out because he was denied his constitutionally enshrined right to have a hearing.
Yes. If the Constitution requires such a baseline, that conflicts with the with, number one, the Franklin decision, which stated that resentencing is not necessary, and the Montgomery decision from the United States Supreme Court, which did not require a baseline hearing. And that court actually approved of a Wyoming statute that does not provide for a baseline hearing, that allows offenders for the first time to prevent such youth-related factors at the parole hearing. And
well, I think we can agree with you and essentially stick to Franklin, which said that this is statutory, and we don't really need to go any farther on resolving whether it's also constitutional, because it is statutory requirement. I guess I'm just kind of wondering what I mean, you said that the parole board's inquiry is in essence forward-looking, but the very notion of rehabilitation is also backward-looking. I mean, it must be, because it connotes something about change, and in order to explore the concept of change, one needs to know where one started, right? So the whole notion of rehabilitation means something about, you have to have a baseline of knowing where this person started in order to understand how they changed. The concern, I guess, from the other side is that even at 10 years or 15 years or however many years, with each passing day, it becomes more difficult to locate witnesses, to find records, to explore the contours of a person's childhood. We know this from the capital context. I mean, it's just very difficult with each passing day. And so I guess I'm just kind of wondering where the essence of, I understand about cases where a person is on the eve of their parole hearing. That just seems kind of pointless. But in the middle space, I'm just kind of wondering, what is your objection to enforcing the statutory requirement in that context?
Depending on the facts of any particular case, we might not have an objection. And
because the facts had been developed already, you're saying? I'm sorry. You mean you might not have an objection because there might be a good cause to have such a hearing. But then presumably in other cases you think there wouldn't be good cause to have such a hearing?
I don't know. I can't speak to every possible scenario. But just because there's not a baseline hearing doesn't mean the Board of Parole Hearings doesn't have anything to look back on. They can look back to the facts of the crime itself. They can look back to the general age and conduct of the juvenile offender at the time. They will have access to the juvenile offender's file from not only the court case, but also his incarceration up until that point. And the Board of Parole Hearings would be able to evaluate rehabilitation in that regard as far as his conduct in custody.
So for a particular offense, what are the kinds of facts that you believe might militate in favor of having a Franklin hearing?
If I understand your question, what facts would
cut in favor of going forward with the Franklin hearing?
Well, I might characterize it as what facts might benefit the defendant to present that weren't necessarily presented at the trial.
What circumstances in a particular case would suggest that a Franklin hearing would be necessary or useful in your mind?
I can't speak to that.
So I gather your argument is they're not always necessary. They're going to be necessary sometimes, but when depends on circumstances that we cannot assess and that you are not certain what they are.
Well, not in this particular case, and not without evidence regarding the procedural circumstances that the Board of Parole Hearings goes through to make these determinations.
I think that's sort of an odd position because, I mean, just from a judicial efficiency and effectiveness perspective, I think what you're essentially saying is that every case has to be taken on its own facts, and a reviewing court would then be in the position of having to evaluate, in essence, the delta between what the defendant claims he or she would like to be put in the record and what the record already shows. And you're saying if that delta is not very big or non-existent, then there should be no hearing.
No, I'm not saying that.
Is that not what you're saying?
No,
okay,
what I'm saying is that if the delta is small, then that doesn't negate the possibility that the person receives a meaningful opportunity to obtain release at
That's
the
what I
youth
mean,
offender
without,
parole
without
hearing.
without a Franklin remand.
Right.
Right, yes. So you're saying we have to evaluate that differential, in essence. And as in this case, you're saying that Mr. Rodriguez has had ample opportunity to put on the record the things that are relevant, and there's no need.
And no, we haven't stated that either.
Okay, I'm sorry. There will be cases where you think that is the case. You're raising that as a possibility.
It is
My
a possibility.
only point is, why should we have that inquiry in every single case instead of just leaving it to the trial court to make that very inquiry on a remand? They're closer to the situation. They know what the facts that could be developed and that would be proffered by the defense would all be evaluated there against the existing record. It just seems like either we're going to do this inquiry here or we're going to do the inquiry there. But it's going to be done at one place or the other. On your fact, you want it to be case by case. In essence, you're just sort of moving up the chain of judicial inquiry where that very inquiry is going to be done.
This is the only case that I'm aware of where a Franklin remand has not been granted by a court of appeal. And I'm not aware of the frequency with which our office has conceded that the Franklin remand is appropriate, but I believe it is the vast majority, if not all, of the cases. And so drawing that line may only be relevant in this one case in which it is not relevant because we've conceded that they are entitled to the Franklin remand hearing.
What do you envision happening on that remand hearing? What instructions would you have us give about what is to happen on remand?
The same instructions given in Franklin. Unless there are any other questions, I'm prepared to submit.
Thank you, Mr. Indermill.
Your Honors, the Attorney General's main point is that a Franklin remand is not constitutionally required. And I know this court said in Franklin it's not. I would like to suggest to you perhaps it is. Because the legislature expressly said...
United States Supreme Court said that it is?
No.
Okay.
I'm sorry. Ask again?
Has the United States Supreme Court said that it is?
Not yet.
Okay.
The legislature has expressly said that the purpose of the act, and by that they mean enacting sections 3051 and amending section 4801, was to establish a parole eligibility mechanism in accordance with Miller and Graham. That's Stats 2013, Chapter 312, Section 1. So although the youth offender parole hearing is a creature of statute, the statute itself incorporates by reference United States Supreme Court cases that are concerned with the Eighth Amendment. And therefore, I suggest, incorporating by reference, there is an Eighth Amendment concern in how these youth offender hearings are carried out. I want to point out to the court that in this case, the District Court of Appeal already held that both Mr. Rodriguez and Mr. Barajas had a sufficient opportunity to put factors on the record at the time of their sentencing hearings. That clearly is not the case. Even more egregiously, and I'm not criticizing the Court of Appeal, I'm saying this is a problem, the Court of Appeal found these sort of Miller factors so unimportant that they did not even allow Barajas' fitness report to be augmented to the appellate record because the court expressly said, in denying that request, we don't see how it can affect the Miller-Caballero question. The trial court is the right place to remand these cases for a trial judge's determination of whether or not there was a sufficient opportunity to put factors on the record. Does the court have any questions? I thank the court for its attention.
Although I requested 4 minutes for rebuttal, I do not have anything to rebut. Therefore, if I ask the court if it has questions. Thank you. We submit.
Thank you, Ms. Klein. Thank you, Mr. Indermill. Matter is submitted. In the matter of the People versus Warren Justin Hardy, we welcome the Honorable Lamar W. Baker, Associate Justice, Court of Appeal, 2nd Appellate District, Division 5.
Good morning. May it please the court. I'm Susan Shaler on behalf of Appellant Warren Hardy. I plan to address the faulty verdict form and the Batson-Wheeler issue. The verdict form leaves no confidence that the jury found the elements required for first-degree murder. And there are 3 reasons that support this conclusion, which I'll address. The instructions themselves, which were erroneous, the defective verdict form itself, and then the closing argument of the district attorney, which exacerbated the former 2 problems. What we do know from the verdicts is that this jury found that my client was not the actual killer. On 6 separate occasions, they handed up true findings that he had not used a weapon personally, and on 6 other occasions, they were unable to reach findings on whether or not he had used a weapon personally. Going to the instructions, we know that 3.02, the aider and abettor under the natural and probable consequences instruction was wrong under People versus Chu. The other murder instructions do not assist in clarifying this verdict form because the definition of murder given in 8.10 talked about murder in its elements that a human was killed, the killing was unlawful, and it was by malice or felony murder. There was no actor, and it doesn't say that my client committed the murder. This was a multi-perpetrator case, and this jury was repeatedly told that my client could be held responsible, could be found guilty based on the actions of the other 2. The felony murder instruction 8.21 listed 7 felonies, and I think the problem with that instruction is best exemplified or illustrated by the chart at page 261 of the opening brief, because that felony murder instruction is fine when there's 1 felony, but here we had 7. So there was this mishmash of the target felony offense and the felony offense that might have resulted in the murder. And the same argument, the same problem exists with 8.27, which is the felony murder, aider, and abettor instruction. And we know the jury was confused by these instructions because they asked. They asked about second-degree murder. The supplemental instructions that the court gave did not clarify the verdict form because, first, the jury probably used an erroneous method under Chu to reach the guilty verdict in the first place. And second, the court gave only 2 supplemental instructions to the jury's question about second-degree murder. The first was the basic definition, 8.30, which just defines second-degree murder. The second instruction that was given was 8.71, which tells the jury what to do if they unanimously doubt whether it was first or second-degree murder. This court has criticized that instruction, 8.71, but has, in other cases, held it's fine because other clarifying instructions make it clear that that unanimously word is not misplaced or misleading. But those instructions were not given in this case, and the instructions that were missing were 17.10, which is the implied acquittal first rule, and 8.74, which tells the jury how to deliberate on a lesser. Turning to the form itself, all of the wording, all of the verbiage and the findings above the words circle all of either A or B have to do with the murder. What degree it was, whether my client personally used a weapon in committing it, and whether he was the actual killer. Everything refers the jury upward. The above entitled action, the above entitled action several times. It's not until the 5th paragraph that any special circumstances are discussed. So what we have in the sections that logically concern murder, we have the jury circling B, an aider and abettor with intent, or a major participant who acted with reckless indifference. And that second clause of the section circled B is not a theory that supports first-degree murder.
Because? Just close the loop.
Because we're missing the intent. With the aider and abettor, if it just stopped there, aider and abettor who had the intent to kill, that would support first-degree murder. But a reckless indifference to human life does not support first-degree murder. That's second-degree murder at most. And that's what we have here. And there would be no reason why the instructions on special circumstances, 8.80.1, would have clarified anything for the jury, because it wasn't until the fourth paragraph that reckless indifference to human life is even mentioned, and it's buried in all of the descriptions of the 7 felonies. We don't have to have a verdict form, and we don't have to have a verdict form that parallels the language of the instructions, but we cannot have a verdict form that appears to conflict with the instructions given by the court, and that's what we have here. And finally, we have the closing argument of the prosecutor at pages 2235 and 2236, where she repeatedly tells the jury that that my client is responsible for all of the crimes, even if he didn't commit them, and if he intended to commit only one of them. She gave the classic example of a bank robbery with a getaway driver and 2 people who entered the bank. But that's the simple and easy example, and it's correct, but it doesn't apply to this case because we didn't have one Section 189 felony.
Is there an objection below?
No, there was not. But I don't think there was a forfeiture in this case, because there has been no case from this court that has upheld a verdict on a form where it appears that an element of the crime is actually missing from.
I'm not talking about the verdict form. I'm talking about whether or not there was an objection during the argument that you say was improper.
No, I'm not saying the argument was in itself improper. I'm saying in combination with the instructions and this verdict form, it was improper.
Thank you for that clarification.
Yes, thank you for the question. So it would be analogous to the jury handing up a verdict that said, we find the defendant guilty of robbery. If it had stopped there, fine. But it didn't stop there. It went on, and in the robbery example, if the jury also circled an option that said, we find the defendant accomplished the taking by force or fear, that would call, with or without force or fear, that would call into question whether or not the force or fear element was actually present or not. Turning to the Batson-Wheeler issue.
Before you leave the
Yes.
Instructions, suppose we agree with you on your Chu argument that there was error. Can you address the issue of prejudice?
I think there is no question that there's prejudice, because it cannot be determined how this jury arrived at its guilty verdict. It's just as likely that it found guilt based on the natural and probable consequence doctrine, which is improper under Chu.
Was it instructed on the natural and probable consequence?
Yes, Your Honor, it was. 3.02 gave the natural and probable consequence, and it was an argument specifically made and advanced by the prosecutor in closing argument. Unless there are other questions. On the Batson issue, there are 5 reasons that show why it was more likely than not that the challenges made to African American jurors were improperly motivated. First, the numbers themselves. 3 out of 4 of the prosecutor's challenges were to African American jurors. So she used 33% of her challenges against a group that comprised only 3.71% of the available juror pool. Second, there were errors in her claims or her reasons why she challenged the jurors.
Counsel, what should we make of the defense's failure to say something at the time when those reasons were offered?
I think the reasons stand and fall on their own, and the court made a finding, although without any analysis, that the reasons were race neutral. So I don't think it was incumbent upon the defense counsel to lodge specific objections or engage in a juror comparison.
So that silence should not play any role in our analysis ever?
Well, I think not when the problems with those reasons are apparent from looking at the record itself, the totality of the record, and these reasons are erroneous or unfounded based on that totality of the record. The third reason is because of the desultory questions or lack of questions that the prosecutor posed to these prospective African American jurors based on her claimed reasons for challenging them. And the fourth reason is that the judge made no sincere effort to evaluate the prosecutor's reasons, but simply held and concluded that they were race neutral. And finally, the juror analysis, the comparative juror analysis, demonstrates the problem. Looking at Juror 2041, one reason the prosecutor gave was clearly wrong. She said that the juror said, police are not always truthful and tend to exaggerate.
Was any complaint raised about that at the trial?
No.
Did you raise that in your opening brief?
Yes, Your Honor, I did.
You did?
Yes, I identified the issues, the claimed reasons. I analyzed each claim reason and explained why each claim reason was either wrong
Opening
or...
brief, did you talk about the police prosecutor, Miss whatever it was?
I believe that I did, Your Honor, yes.
Why, in your view, does that mistake matter for purposes of answering the ultimate question under Batson-Wheeler, which is whether the strike was motivated by improper considerations of race?
It matters because if the juror had said, I think the police exaggerate and are untruthful, that would have tended to suggest a bias against prosecution witnesses. What the juror actually said was he thought prosecutors and criminal defense attorneys are not always truthful and tend to exaggerate. So that his actual answer gave no suggestion of bias against the prosecution.
Okay, so he's biased against everybody. He doesn't believe anything a lawyer says. Wouldn't that give a trial advocate some pause?
His reasons for saying that, as he explained, were based on what he had read in newspapers and heard on TV.
But we can debate whether or not it's a fair conclusion and whether or not we as judges and lawyers like it. But if he believes it, isn't that a legitimate concern?
I grant that it is.
Going to give him homework to go back and watch different TV shows or read more about how swell the system is.
I understand, but there are two problems. First, the prosecutor's answer reason was wrong, and second, she asked absolutely no questions about this reason that supposedly gave her so much.
What would you have to do? Say, tell me more about why you don't like lawyers?
Well, he didn't say he didn't like lawyers. In fact, he went on in other parts of his question.
Civil lawyers are good, but he certainly doesn't like prosecutors or defense lawyers.
He said that they're not always truthful and tend to exaggerate, right?
Yes, he did say that.
Did he say anything more than that?
No, he did not.
But why would a prosecutor, or even a defense attorney for that matter, want a person like that in the deliberations room? They're a gamble. You don't know which way that they would be able to, what they would say to the other jurors. I mean, because he did say he speaks to attorneys daily and he knows 50 to 60 civil or criminal lawyers. Either side, I could see, may not want this fellow on the jury.
Again, Your Honor, there were no questions asked of him, and he also went on in other portions of his questionnaire to say how much respect he had for the legal system and for the court system and for judges. And as far as knowing the attorneys personally, we also have seated white juror 8868 who was friends with the city attorney. And the prosecutor also made a generalized statement that she just felt 2041 would not be a good prosecutorial juror. But she asked no questions again about this, but his answer to question 106 was that we should hire more law enforcement. His answer to question 107 was, I don't believe in too many mitigating factors. People have choices. In question 110A, he said he favored enforcing strongly the current laws.
But I think that argument presupposes that in an analysis like this, we go back to decide whether or not there are other good reasons to keep the juror, and I don't believe anyone, us or the United States Supreme Court, has said that that's the case. It is often the case that jurors present a mixed bag. They say some things that are positive, and they say some things that are hair-raising. And each advocate has to make a judgment about whether or not, from their perspective as an advocate, the positive answers outweigh the risk presented by the hair-raising answers. That's a legitimate approach to jury selection, is it not?
Yes, it is, which is why it's important to look at how this prosecutor viewed the answers from African-American prospective jurors differently from white jurors. For example, the prosecutor said that 2401 had indicated LWOP was worse for the defendant. That was question 198 on the questionnaire. White-seated juror 1938 gave the same answer. White-seated juror 8868 gave the same answer. White-seated juror 9710, that was an Hispanic juror, 9710 gave the same answer. And two jurors put a question mark in answer to that question. So that demonstrates that answers that a black perspective, an African-American perspective juror gave were viewed more critically and in a different way from the answers of non-African-American.
Does it actually demonstrate that? I mean, presumably the prosecutor in exercising peremptory challenges is looking at the entire package of the jurors, right? I mean, and so as Justice Corrigan says, each one presents a mixed bag, and maybe the prosecutor overcame some reservations about certain answers because there were other things that recommended the particular juror that didn't recommend the one that the prosecutor struck. How are we to determine which is the case, whether the prosecutor was really sort of applying a different standard across the board to African-American prospective jurors, or simply in an individualized way weighing the pluses and minuses of prospective members of the jury and making a neutral determination?
We can only know what the prosecutor stated as her reasons. And going through those reasons for each, particularly 2041 and 4826, those answers either make no sense, and by make no sense, for example, with juror 4826, the prosecutor said she suspected that this juror 4826 had special knowledge of jail procedures. Well, as in the Wasco issue case this court just decided, what difference did that make about this case? There was nothing about this case that was important about jail procedures, and the prosecutor said she suspected this about the juror. She asked no questions. And we had two seated white jurors, 13164, who worked closely with the LA Sheriff's deputies, and white-seated juror 4635, who worked with the Long Beach Police Department for charity. That was the very police department that investigated this offense. So I think we have to look at the answers that she stands or falls on, and whether those are supported by the totality of the circumstances of this record, and they are not. Unless there are questions, I reserve the rest of my time.
Thank you, Ms. Shelley.
Counselor, before you begin, my recollection, and you can correct me if I'm wrong, is that you, in your reply brief, raised the police prosecutor issue, that raised the misstep by the district attorney in using police rather than prosecutor.
Correct, Your Honor.
That was my recollection, and I want to thank you for doing that, because it's not necessarily in your favor. I'm not saying it's not in your favor, but we always prefer transparency.
Thank you, Your Honor. May it please the court. Certainly, the prosecution wants impartial jurors. Jurors are not extremely biased either way, either for the prosecution or for the defense. And I'll just very quickly cover a few of the reasons as to each of the three jurors. Certainly, as Justin Corrigan stated, it's a totality examination. And what the defense loves to do is take one particular reason and then find that reason in a non-challenged juror and apply that singularly, which you can't do. You have to look at the entire juror, the entire package. As the court well knows, it's a chess game. There's pieces constantly moving. You may have one juror you're comfortable with, but then there are peremptories and the panel shifts, and now you're comfortable with that juror, but you are no longer comfortable because of the inclusion of another juror. So all of this is happening at the same time, and it's the prosecutor's job to secure that impartial jury. And when you look at FG, prospective juror number 2041, as counsel stated, believed that life without parole was a worse punishment for a defendant than death. But he also stated, as the court noted, prosecutors were not always truthful, tended to exaggerate. He stated that the three most important problems with our criminal justice system were misleading evidence, wrongful accusations, and the appeal process.
Did the prosecutor question any other jurors who had similar views about whether the severity of the penalty?
Yes, Your Honor. I mean, that's where we're fortunate in this case. Unlike some of the other cases which have made it to this court where there was a truncated voir dire, we have extensive written voir dire in this case, and we have extensive...
Aren't there two sitting jurors on his jury who also said that life without parole is worse?
Yes, correct, Your Honor. But again, we're looking at the...
Prosecutor questioned either of those jurors regarding those views?
I would have to go back and look at the record, Your Honor, specifically off the top of my head. If the court says the prosecutor did not, then obviously they did not. That's in the record, but...
Did the prosecutor question other members of the sitting jury regarding their contacts with lawyers? There was at least one juror who was, I believe, a legal secretary for some number of years, knew lots of lawyers. Two other jurors who had lawyers in their families. Did the prosecutor question any of those people regarding that concern?
I do not believe so, Your Honor, but no prospective juror said anything.
Prosecutor questioned any juror, any sitting juror regarding their desire not to sit on the case because of the nature of the crime?
I do believe that came up in the for cause challenge with respect to, if the court would just give me a moment. I do believe that came up with juror DD, perspective number 6840. But again, Your Honor,
I think, what I'm getting at here is, I can go down the list. There's also the reason given about juror 2041's arrest. There are other sitting jurors who had also similar experiences with law enforcement. In fact, jurors who reported negative experiences with law enforcement, which juror 2041 did not. So my point is, you suggest we have to look at a totality, which is what I'm suggesting we do here, and there's a pattern.
Well, again, Your Honor, the problem with that argument initially is you're jumping right into comparative analysis, and we're not at comparative analysis. We're in stage one. So,
well, we're not under stage one because the trial court decided to rule on the stage 3 issue. And under People v. Scott, we have held that that is a stage 3 case as it comes to us.
Respectfully, Your Honor, my reading of People v. Scott seems to very clearly state that if the judge does not find a prima facie case, the prosecutor volunteers reasons, and even if the court comments on those reasons, even offhand, as a trial court did in this case, it is still a first-stage case. I mean,
Counsel Scott drew a distinction between simply the presence of reasons on the record because the prosecutor volunteers the reasons, and a situation where the trial court actually rules or effectively passes judgment.
Correct. Correct, Your Honor. And the court certainly did not do so in this case. And the court certainly shouldn't punish either the prosecutor or the court for, precisely the circumstances in this case, because what the court wants is a good record. And we have a very good record here. As we know, in stage one, the court can look at the entire record of voir dire because that avoids a remand later. For example, if this court was to determine, okay, well, the court ruled incorrectly, the prima facie case has been met, therefore you have a record that the court can examine because those reasons are all there. So I think that, Scott very clearly, I disagree, Justice Liu. I think Scott says this case right here is absolutely a first stage case. And again, the defense immediately wants to throw their burden on the people, jump right to comparative analysis, pick a couple factors that apply to one juror and say, oh, look, and of course you can do that because there's literally, particularly in capital cases, particularly with this type of extensive voir dire, you can parse through that at length and find these individual reasons and say, look, he said this and he said this. Well, you didn't excuse him. Well, yes, because this juror I did excuse also said this, 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 and this. I mean, I have in my notes 10 factors for juror FG, and there's no other juror that's even close. I mean, that's certainly not a close call. I mean, he said he spoke with lawyers on a daily basis and knew about 50 to 60 civil and criminal defense attorneys. He didn't say prosecutors. That clearly indicated defense bias. And Justice Liu, there's no other prospective juror who said anything close to that as far as his experience.
So, counsel, in this case, when the prosecution offered reasons, defense counsel was silent. What role, if any, should that play in our analysis?
Your Honor, I mean, the court certainly weighs that as defense counsel, certainly is down there in the courtroom. It accepted the reasons due to the lack of objection. I think it plays a very heavy role. And I also think the fact that the prosecutor accepted this panel twice with juror 4826 should also play a very heavy role. But again, defense counsel was down there. Defense counsel could have objected, could have said something, but all the reasons are certainly in the record. The court can consider that in the first stage analysis, and defense counsel didn't say anything at all. But then on appeal, again, we want to parse through all these hundreds of pages of jury questionnaires just to find the one or two things and jump right into comparative analysis, and the court can never do that. I mean, we'll never get juries selected in capital cases. I mean, this trial court, Judge Lord was particularly thorough. From the people's perspective, did a particularly good job with the written questionnaires, with ensuring that there was extensive oral voir dire of the jurors. I don't believe there's even been a complaint that, voir dire was truncated, that it was cut off, that, either the defense attorney or the prosecutor didn't have a chance to do their job.
Can you refresh my recollection? How many days of oral voir dire were there?
I cannot, Your Honor, but,
fair enough.
But
we can find
several. I will certainly submit research that and submit a letter brief.
We have it.
I don't disagree with the thoroughness of the process that led up to the Batson motion being lodged and then considered. But I think the difficulty here is that the trial court didn't say very much with respect to the actual merits of the Batson ruling. I mean, the court just says, as I have it here, the court doesn't believe there's a sufficient showing to meet the prima facie finding. Even if the court had reached that point, the prosecution has explained race-neutral reasons for excusing the jurors. That's where I think it is a third stage case under Scott. You may disagree. And then pontificated a little bit that some of the reasons were out of the ordinary, not sure that he would have done so if he were a lawyer, but that's not a reason not that's not a reason to grant the motion, so the motion is denied. That's the totality of the analysis, I think. Am I missing anything?
No, Your Honor, except for the entire record of voir dire as part of the trial court's analysis, which the trial court sat there and heard. And if you look at People v. Scott, and it states verbatim in sum where the trial court has determined that no prima facie case of discrimination exists, the trial court allows or invites the prosecutor to state his or her reasons for excusing the juror for the record. The prosecutor provides non-discriminatory reasons, and the trial court determines that the prosecutor's non-discriminatory reasons are genuine. An appellate court should begin its analysis of the trial court's denial of the Batson-Miller motion with a review of the first stage ruling. This is exactly what we have here. I mean, we cannot jump right into comparative analysis without a prima facie case. I do think one thing that would be helpful is I term it as 7 factors. I think it is clear from the case law if you delve into it, but certainly the court could restate those 7 factors. A party has struck most or all of the members of the identified group from the veneer. That would seem to weigh in favor of the defense in this case. That a party has used a disproportionate number of strikes against the group. That weighs in favor of the prosecution. There was 33%. 55% of the strikes here were against white jurors. 3, that the party has failed to engage these jurors in more than desultory voir dire. Again, weighs in favor of the prosecution, extensive voir dire.
True that the prosecutor here struck every black juror that the prosecutor could have struck.
Correct, Your Honor. That is a factual statement. However, if defense counsel, again, going to Justice Cuellar's point, wanted to change the racial composition of the jury or was somehow unhappy with that, he had peremptory challenges remaining and could have done so. Just because a particular juror happens to be black but is not an impartial juror, and the prosecutor believes that juror is going to either create a hung jury or be a problem in the jury pool, doesn't mean that, or in the jury deliberations, doesn't mean that the prosecution has to keep that particular unique juror just to keep one black juror on the panel, and the court has said that many times.
Well, I take that point. I want to go back to what I thought I heard you say at the beginning of this presentation, which was, well, the defense had challenges, and if they didn't like the composition, they could have challenged some people to get a different composition. I don't think that's the standard. I think when we look at a Wheeler-Batson challenge, we look at what the representative of the government did and whether or not challenges were exercised for an illegitimate reason, and B, whether the prosecutor lied about it. So I don't think you can have as a make-weight, well, if they didn't like the composition of the jury, they could have exercised some challenges and maybe gotten a different mix. If I'm misunderstanding your argument, now's the time to disabuse me, and if I'm understanding it correctly, I'm disagreeing.
No, you are correct, Your Honor, and I was addressing Justice Cuellar's point about, the actions of defense counsel and how the court should weigh that, and that's
More
just
a question than a point, but I take your point.
Continuing, Your Honor, the fourth factor, that the defendant is a member of the identified group, certainly weighs in favor of the defense. That the victim is a member of the group to which the majority of the remaining jurors belong, again, weighs in favor of the defense. And then, the court may also consider non-discriminatory reasons for a peremptory challenge that are apparent from and clearly established in the record. Again, first stage, we can consider the entire record of voir dire. And then I would say, 7, that certainly, if we're going to consider whether a party has struck most or all of the members, Justice Liu, we certainly have to consider whether the prosecutor has accepted the jury with those particular individuals, which the prosecutor did here, because essentially what we're saying is this is very bad. The prosecutor is doing this for racial reasons, and when the prosecutor is accepting the panel with 2 members of this race, I think that completely refutes that argument. I mean, if the defense had not made another peremptory challenge, that juror would have been on the panel. So obviously the prosecutor is not excusing that person on the basis of race, what he's doing, as I mentioned before, is he's looking at how this jury is developing. He or she is weighing all the factors, and then he determines, hey, look, this one juror said she, I think it was MF, had a mind of her own and does things her way. And then I realized it was a for-cause challenge, but just as an example, DD said, I do things my way. Well, maybe the jury shifts enough, and then you end up with those two on the same panel. As a prosecutor, I am not going to take both of those prospective jurors on my panel. I don't want two rumblefish in the same tank. I'm going to excuse one of them based on all of these factors, looking at the big picture and how my panel is unfolding. And this is a capital case, a death case, which makes it all the more difficult, typically more lengthy, typically a lot more witnesses, typically a lot more burden on the people if it's reversed on appeal. So
I want to make sure, again, I understand your point. Two rumblefish in the same tank, huh?
Well, Your Honor, if you're unfamiliar with rumblefish, if you put two of them in the same tank, they will kill each other.
This list of 7, are you suggesting that this is a list of 7 factors that the trial court should consider in terms of whether or not there's a prima facie showing, or that this is a list that we should apply or the courts of appeals should apply?
Well, I'm saying that the court has essentially done that in Scott. I think it would certainly help to state that, in this, for the prima facie case, correct, Your Honor.
Okay, so it is because it's conceivable there are other factors that might be taken into account on review of a lower court ruling.
Correct, Your Honor, but when I read through Scott and the case law and, put all of this together, and the court has done that in Scott. I mean, we have the test, but I think it would certainly help. The people would like to see, a very clear acknowledgement of, hey, look, if the prosecutor is going to, accept members of that race in the panel and they later get excused, I mean, that should be something that this court expressly, tells courts of appeal and trial courts that is a factor we want you to consider, particularly if we're telling the trial courts to consider whether he struck most or all members of the identified group. Okay, Your Honor, just very quickly, I just wanted to comment on defense counsel's argument that appellant was not the actual killer. The jury made no such finding. I do not think that is true in any analysis of the underlying facts. We know that appellant punched the victim twice in the face. We know that he bit her on the breast, which left DNA evidence, which almost certainly means that it was an exposed breast, not a breast covered with clothing. We know that she had multiple injuries to head and neck areas. And particularly in this case, Dr. Jaborian, the coroner, he really couldn't even state the exact cause of death because the victim was so battered. We had 94 external injuries, 20 internal injuries. He could not exclude manual strangulation, nor could he exclude stomping on the neck, which could cause asphyxiation. So to say that appellant was not the actual killer, that is false based on the facts. And certainly the prosecutor was not proceeding in this case on a natural and probable consequences theory under any stretch of the record. There were felony murders here. We have 5 special circumstance allegations. We have 8 underlying substantive counts. And overall, with respect to any issue that has a prejudice component in this case, there is simply no possibility of prejudice based on these facts. And finally, just in closing, I would encourage the court to specifically rule on the forfeiture arguments. There are many of them, as this court is aware, and that is extremely helpful in later proceedings, particularly in federal court. So I would strongly encourage the court to do that. The people ask that the court affirm the conviction and the sentence of death in this case. It is certainly well-deserved.
Could I just clarify one point about our discussion about People versus Scott? And I apologize for not raising this earlier. The crucial distinguishing factor about the sequence of events here is that in Scott, the trial court ruled on the prima facie question before hearing the prosecutor's reasons. Here, the prosecutor gave the reasons, then the trial court ruled. And then it ruled in the alternative. It said there's no prima facie case, but even if there were, I find no discrimination. I think if you look at our cases in that situation, it is a third stage case because the cat is out of the bag and the trial court has not issued the prima facie ruling at the appropriate time, which is before hearing the reasons. Right? So I just wanted to offer you that clarification because this is not squarely governed by the rule you stated in Scott, although Scott discusses some of these permutations.
Again, Your Honor, respectfully, I disagree because I think the court at best made an offhand comment. And certainly, a trial court, looking at this opinion, perhaps, if it turns out that way, court's not going to say anything. I mean, we want a good record. And when you look back at what the trial court said, you have a court saying, hey, look, there's no prima facie case. If the trial court, finds no prima facie case, then, the people would argue, by definition, this court should start with the court's determination on the prima facie case. And there's no reason not to do that because this court can certainly determine that the court was wrong. And then we have the record, and then the court can proceed along to the third stage. But just to jump right into comparative analysis and take the burden that's clearly on the proponent of the motion and throw that right on the people, well, of course, that's what the defense wants, but that's not the precedent we have from the United States Supreme Court, and this court should not do that. Thank you.
Thank you, Mr. Wise.
I have 8 points. First, it defies logic to say that this verdict or this jury could have found my client was the actual killer. They had that choice on the verdict form, actual killer. They rejected this. In People versus Pearson, this court concluded, based on a very similar jury form, that the jury had convicted using an aider and abetter theory. My other points concern Batson. So first, the deputy has supplemented the reasons that the district attorney gave for challenging these jurors. That's not permissible. What's permissible is to look at what the district attorney said. Second,
but the record does show that 2 blows to the head were struck by the defendant.
I'm sorry, I could not hear you.
2 blows to the head were struck by the defendant.
Yes.
10 blows to the head.
Excuse me. I think the evidence was punches.
Okay.
From my
But
client.
the autopsy shows that there were 10 blows to the head, and the doctor could not say which one of them caused the death or which one of any of the multiple injuries caused to the victim caused the death.
That's correct. And there was evidence that Pearson used boots to stomp the head, and my client admitted to punching the victim. Returning to Justice Liu's question about the jurors who didn't want to sit on the case, this was the only question or the only area of concern that the prosecutor actually asked juror 2041 about. But we had several jurors, 5 seated jurors, had similar reluctance and to sit on this jury. And in fact, 1 seated white male juror, 3164, had a concern about sitting on any case that lasted over 10 days. 2041's concern was about a case that lasted over 30 days, and he was questioned about that, and the judge assured him it would not be over 30 days, and any conflict he might have about testifying in Santa Monica, Judge Lord could take care of because he had some pull with the Santa Monica court. Even if this is a first stage case, all of the People versus Wheeler, all the People versus Box factors are met. Respondent has agreed that the district attorney struck most or all of the African American jurors. We say, and we disagree on this, that there was a disproportionate number of strikes against African American jurors. Whites comprised slightly less than 2/3 of the available jurors, 63% almost. They ended up being seated as 75% of the main jury and 75% of the seats for the combined 12 jurors and 4 alternates. So
Would you have any response to the observation that the prosecutor passed twice with 48-26 on the jury?
That is correct, but the prosecutor never passed on a panel that contained, as seated jurors, an African-American juror. And to have an African-American as the fourth of 4 alternates, we might as well not have an African-American there, because as this trial judge said, we're probably not going to seat an alternate in this jury. As it turned out, one was seated. Returning to Justice Cuellar's points and questions about the silence of the defense counsel, Gutierrez tells us that counsel and the trial court below have a duty to make a record. And I acknowledge that defense counsel was silent, but so was the trial court. There was no analysis and no sincere effort to evaluate the reasons that the prosecutor gave. And if we look at the voir dire was extensive because there was a 53-page, 237-question questionnaire. And as respondent has noted, the trial judge gave the attorneys the ability to ask almost unfettered questions. So what did the prosecutor do with that discretion? The defense attorney asked 25 questions of juror 2048. The prosecutor, with all her concerns about all these things, asked a total of 8 questions.
In this particular trial, who did the judge let go first? The prosecution or the defense in terms of asking questions?
The court asked a few questions, and then the defense attorney asked questions, and then the prosecutor asked questions. That was the way.
The prosecutor is entitled to consider the fact that this juror has now been, or this potential juror, has been questioned by 2 other people at some length, right?
Oh, absolutely, Your Honor.
So you aren't suggesting that there be a rule that we count up everybody who asked all the questions and then determine whether or not the one part of the question was dulcitory. If the result of that approach would mean that there will be many, many more days of voir dire.
Yes, that would be the result, and that's not what I'm suggesting. But what I am suggesting is, based on the questionnaire and based on the defense counsel's questioning, the prosecutor had an idea of her areas of concern, yet she only asked about the one, and that was the length of the trial. And that's why those factors with juror 2041, and when we get to the comparative juror analysis, how aspects that the prosecutor identified about the prospective African-American jurors weren't of concern to her for the white jurors and seated white jurors.
So, counsel, your time's expired, but I'll give you 30 seconds to wrap up and close.
I have nothing further. Thank you very much.
Thank you, Ms. Shaler. Mr. Wise, the matter is submitted. We stand in recess.